Additionally, there was a petition filed for injunctive relief. The court determined, even without a proof of service, that because of the nature of the proceeding, that I needed to put it in the middle of our case call, and that we would let parties come forward and say what they needed to say in as quick a manner as we could. The court has not ruled on the petition to intervene filed on behalf of the Democratic Party, but did afford them the opportunity to file papers as if they were an amici, while the court made a determination of any standing and whether or not intervention would be granted. With that, the court set a hearing for 11:30, thinking that my morning call for the Court of Claims, for the Court of Appeals rather, would be done by then. Unfortunately, one of my colleagues had no power. And so it took us until about 10:40 to even begin the Court of Appeals docket, and it just concluded. I am very apologetic about that and appreciative of the patience of all the parties in this case. As you can imagine, I have done a speed read of the multiple pieces of paper that were filed. The defendant did in fact file a response to the request for injunctive relief. And about 2 minutes ago, the amici filed papers, which I can earnestly tell you I have in front of me, but I have not read. The way in which I'm going to proceed today, without affording the proposed interveners intervention, because this is going to have to be managed today and fairly quickly, I am going to give them the courtesy of brief oral comments, and I will give them that courtesy after the named parties have spoken to whatever issues they deem appropriate. Are we clear on at least how we're going to try to get through this?
We are, Your Honor.
Okay, with that, we begin, please, with counsel for the plaintiff.
Yes, Your Honor, thank you, and good afternoon. From the plaintiff's perspective, what the relief we're asking this court to grant is very simple, is simply to direct that Secretary Benson order that the election counting authorities and the counting boards that are handling ballots allow challengers who are qualified under Michigan statute to participate and to observe that process. Many of the ballots have in fact been counted. Some are still being adjudication boards are still being convened. And so the request is simply that Eric Osterden, who is a named party, as well as the Trump campaign and their designated challengers, be allowed to participate and meaningfully observe that process.
Counsel, I guess what I need to understand, in order for me to give injunctive relief, I would have to first find that there is an immediate threat of irreparable harm, and that first, that there's a substantial likelihood of success on the merits. Let's start there. And in order for me to make that determination that somehow you're being deprived of meaningful participation, I've got to make a fact finding. I looked at the affidavit repeatedly, and the affidavit appeared to say to me that there was a person who had been approached by another human being who is unnamed, but described as a participant in the counting process, and that that individual who is unnamed, but a participant in the accounting process, gave information to the affiant that indicated that there was some malfeasance going forward. So what I have at best is a hearsay affidavit, I believe, that addresses a harm that would be significant, but that's what we've got. We've got an affidavit that is not firsthand knowledge. If there is something in that affidavit that would indicate that the affiant observed activity that would be a deprivation of the rights of poll watchers. I want you to please focus my attention on that.
I would indicate, Your Honor, attached to that was a note that was, again, this was a election inspector who was appointed according to the affidavit, that was handling the processing of ballots, that ballots that had been sent in prior or after, excuse me, after on November 4th, after the deadline, were noted to be a ballot that was received timely. And that
Okay,
was,
so I want to make sure I'm understanding you. The affiant is not the person who's had knowledge of this. Is that correct?
the affiant had direct firsthand knowledge of the communication with the election inspector and the document they provided them.
Okay, which is generally known as hearsay, right?
I would not think that's hearsay, Your Honor. That's firsthand personal knowledge by the affiant of what she physically observed. And we included an exhibit, which is a copy, physical copy of the note that she was provided.
And I'm going to see if I can pull up this physical copy of the note, because while I'm doing that, you can continue your argument.
Yes, Your Honor, thank you. And the gist of what we're asking both the court to do and where we have a concern is not just this specific instance, but what we're asking is that the Michigan law, which election code at 168-733 has specific duties for challengers who are able to observe the processing of ballots. And
who has averred that they have not been given that opportunity? Did I miss that too?
That would be Eric Ostrogen, who's the plaintiff, one of the named plaintiffs, who was excluded from the Oakland County Counting Board. And so
his status, other than being a candidate, what is his status?
He is not a candidate. He is a challenger, a designated credentialed challenger, and he was removed from the counting board. And the allegation, not just that that is what he said, but then in addition to that, the Trump campaign has a right as a party and a candidate in this election to have challengers meaningfully participate. And that's what we're asking the court to direct Secretary Benson to allow. We understand.
What do you mean by meaningfully participate? What is it that you believe they have not been afforded the opportunity to do that they have a legal right to do?
Right. So I would refer the court to Michigan statute in the election code 168-733. We quote it in our brief, and it provides the rights and responsibilities of election challengers, which means they have the ability to oversee or to meaningfully observe the election inspectors processing of ballots in the conduct of the election. And that's what we're asking direction from Secretary Benson to the local counting boards, that they make sure that they comply with this. I mean, I can go through the statute. I don't want to take the court's time to read it. We quote it at page 4 of our petition.
Okay, you may proceed.
Yes, so that is the relief we're asking the court to grant, Your Honor, is an order directing Secretary Benson to allow challengers designated by, they can be Democrat or Republican, but to have meaningful opportunity to oversee and observe the conduct of the election, and not to exclude them, but allow them to see how the election inspectors are in fact processing the ballots and authenticating them and adjudicating them.
Okay, I've gone back to your affidavit, and what I have is something that says it entered receive date as of 11/2 on 11/4. And it says that this was coming, it doesn't say, it says the individual who spoke to her was a poll worker with no name. Okay.
That is correct, Your Honor. That's what the, but when you read the affidavit, you will see that Ms. Conaran indicated, who is in fact herself an attorney, Michigan attorney, indicated that the poll worker indicated that this was in fact a, she was directed to basically predate.
I understand, but I'm still trying to understand why this isn't hearsay.
Well,
I absolutely understand that it's what the affiant says she heard someone say to her. But the truth of the matter asserted therein that you're going for is that there was an illegal act occurring. Or because other than that, I don't know what its relevancy is.
Right. I would say, Your Honor, in terms of the hearsay point, this is a firsthand factual statement made by Ms. Conaran, and she has made that statement based on her own firsthand physical evidence and knowledge.
I heard somebody else say something. Tell me why that's not hearsay. Come on now.
Well, it's a firsthand statement of her physical.
It's an out of court statement offered for the truth of the matter asserted therein, right? So if the truth is that somebody told her something, not what they told her, that's one thing. You want me to find the truth, or at least a scintilla of truth, in what she says the contents of that communication were, right?
What we're asking the court to do, Your Honor, is to, on the basis, again, it's not based on what the relief we're asking is not just based on this affidavit. The relief we're seeking the court to order Secretary Benson to direct election officials to allow observers and challengers in Michigan counting jurisdictions as provided by Michigan State Law 168.73.
And I've got to find that they're not doing that in order for me to have a basis to tell them to do that.
Right.
So you wanted me to look at the summons and the complaint because you're telling me that in certain paragraphs of this complaint, I'm going to see that Mr. Ostergen says that he was ousted. Does he tell me the circumstances under which he was ousted? And
he was a designated qualified challenger, and he was told to leave the counting board. That's the allegation that we make. That's the statement that we make in the verified complaint.
okay, you may proceed further.
Again, I come back, Your Honor, to what we're asking the court to do, and I know I said it several times, but it's simply to direct Secretary Benson to have the local election counting boards provide meaningful opportunity for challengers from the Trump campaign, as well as Mr. Ostergen. And frankly, I mean, the other parties aren't parties in this litigation, but we would be fine with the Biden campaign or anybody else having challengers as provided in Michigan law observe the process. And that's really the relief we're requesting.
Okay. In response from the Secretary of State, I don't know who's responding, but.
Good afternoon, Your Honor. Heather Meingas on behalf of Secretary Benson, along with Assistant Attorney General Eric Grill. I guess first I would note, I know the court's aware that we filed a response. That response was to the emergency motion for declaratory judgment that we received on November 4th. We did not receive a motion for injunctive relief that was apparently or purportedly filed today sometime. So I'm not sure of what that pleading says and whether it negates some of the response that we've already provided. But so we've responded to the first motion. I don't have a second motion. And okay, I think it was
Ms. Meingas, what motion? There was no, the original summons and complaint didn't have a motion.
The summons and complaint that we had was accompanied by an emergency motion for declaratory relief.
What
But
we
then
got was, we got a summons, okay. All right,
Okay,
So
so, well, I,
when was the request for injunctive relief served on behalf of the plaintiff?
Your Honor, if I can address that question, it was served both electronically on behalf of the plaintiffs to Secretary Benson as well as the others. And we also had a process server who tried to physically deliver it to the Secretary of State's office, but the office was closed and they could not get access. But clearly the Secretary of State has copies of all the pleadings.
I do not, Your Honor. We do not have a copy of a motion for injunctive relief. I've looked in my email, Mr. Grill has as well. If that could be resent, I'd be happy to look at it. I'm just pointing out for the record, we filed a response to the initial motion, and that's, you know, what I can address today. And I think it's.
And I
it's
think
not
what
gonna be
you're
any different
describing
for-
as the initial motion, you got pleadings in a different way than I did. I got a summons and complaint, period. Then I got additional papers this morning and a copy of a proof of service later this morning. I think that we're substantively talking about the same thing. They just came in pieces.
That could be, Your Honor, and I don't know that it makes any difference. I mean, our arguments wouldn't really be any different in a second motion if it was an motion for injunctive relief. I mean, as we set out in our response, there are numerous defects and problems with the pleadings that have been filed in this case. You know, and most significantly here, you know, there really isn't any relief that can be granted at this time. As set forth in declaration from Director Rader, I mean, the counting boards are done. We have finished counting AV ballots in Michigan. And so there isn't any, you know, there are no more counting boards functioning as far as challengers and precinct inspectors, you know, reviewing AV ballots and processing right now. That those functions are complete, at least as of this morning from Director Rader. And so to the extent that the plaintiffs are requesting that we halt, you know, the processing of AV ballots so that somehow challengers can have some sort of opportunity to review the process, you know, there isn't any more opportunity to do so because the counting boards have completed their functions. So the ship has really sailed on the relief that they're requesting in this case. I think, so we pointed that out through our latches argument to some extent, and also really now what we're talking about is sort of a mootness argument. And I'm also a little bit confused today as to their argument about with respect to the challengers. If you look at their pleadings, the basis of their pleadings is that the challengers were being denied an opportunity to review surveillance video of the drop boxes. That is the basis of their complaint and the emergency motion that we read. So this opportunity for a meaningful review as pled in the pleadings is that they wanted some sort of opportunity to review surveillance video of drop boxes. And so that's how we've addressed our pleadings, our response, because that's how it was pled. I didn't hear any of that
additionally,
today.
Ms. Meingas, they did say in the second paragraph that the named plaintiff was removed.
Right, but if you look, that's why their pleadings are confusing, because their pleadings talk about election inspectors of both parties not being present for various aspects of the counting board process. Mr. Ostergren is not an election inspector, he's a challenger. And so there is some, to me, there is some, we're at 6s and 7s with respect to what the pleadings are actually saying and what kind of is really going on or what the law is. And Mr. Ostergren doesn't explain where he was excluded from, which AV counting board, what day that happened, why he was excluded. And that doesn't even really feed into his exclusion for whatever reason, doesn't feed into the claims that they've pled, which where their arguments are that election inspectors from both parties are not always present at the counting boards to review the process. That's what their claim is, and that challengers are not having an opportunity to review surveillance video. So that's, I'm just going on what the pleadings say, Your Honor, is the source of their alleged injury. And it's not really kind of matching up with the argument that we're hearing from counsel this morning. And again, at this point, it's all really moot because the counting boards are complete. We've moved on to the sort of the second phase. and all of this, all of the unofficial results and all the poll books and all the ballots and all that will be moving on to the county canvas for the boards, the county boards to look at. So, there isn't any relief that can be given at this time with respect to, halting this process and allowing challengers more opportunity to review, or to fix some alleged irregularity and not having precinct inspectors or election inspectors of both parties present for these functions. So, that's what we've principally responded in our response. They also lack standing. And then if you even get down into the merits of their claims, if you even got there, there really isn't anything to it because they don't have an opportunity. There is no right to review the surveillance video. And there isn't really any kind of obligation, as we read the statute, that somehow, an election inspector of both parties has to be present 100% of the time and 100% of the places at the absent voter counting board. So I just feel like there's a little bit of disconnect between what their pleadings actually state and some of the argument that we've heard today.
Okay. On behalf of the proposed intervener present, Amiki.
Good afternoon, Your Honor. Kevin Hamilton for the Democratic National Committee. And first, I'd like to thank Your Honor for the opportunity to appear, and I'll be brief. I believe the motion should be denied for several reasons. First, the plaintiffs have failed to establish an actual controversy under MCR 2.605, which would be necessary in order to pursue a claim, for the simple reason that the factual record before the court doesn't support the relief sought. And in any event, the claim is largely moot at this point for the reasons Ms. Meingas just pointed out, that the county counting boards are largely complete now, and so the relief is simply unavailable. On the first point, no evidence in the record would allow the court to conclude that the plaintiffs have demonstrated a likelihood of success on the merits, which, as Your Honor pointed out a moment ago, is a necessary finding in order to enter injunctive relief here. The affidavit obviously is hearsay, Your Honor, at least single hearsay, perhaps double hearsay. And that is simply insufficient under any standard to justify declaratory relief. Moreover, as we've outlined in our papers, and I know Your Honor hasn't had the chance to review those yet, they've sued the wrong defendant. The Secretary doesn't operate these counting boards. The counties do. They are created and operated by local government. Those local governments, the counties, were not named as defendants, nor could they have been before this court, whose jurisdiction is limited under MCL 600.6419. So that's obviously a problem with the relief sought. On the merits, as counsel just pointed out a moment ago, there's no right to video surveillance of voters casting ballots, whether they're casting them in person or at drop boxes. And counsel doesn't even really pretend otherwise. He cites no statute and no case law that suggests that a voter or a political party or candidate has a right to surveil